Good deal. Chairman, if you want to call us to order, we'll take roll and get started.
All right, then, excuse me, this meeting of the Board of Examiners for Land Surveyors is called to order. Let's see, roll call, we have Justin. Here. Tommy Young.
Here.
Gary Clark, obviously here, and Kevin Martin by
here.
All right, great.
remotely.
All right. Just a couple things we'll do. Just want to remind folks of the notice of public comment period will be located at the end of the agenda. And so you'll have to sign in either in the chat or on here at the podium to speak. And then we'll want to, of course, limit our address to 2 to 3 minutes and things related to the agenda itself. And of course, avoid any sort of repeating comments or want to limit it to new information if we have several speaking on the same topic. Also, I want to just quickly add all of our votes today will be in roll call due to the fact that we have one of our members participating virtually and want to make sure that we include him. So we'll just do a roll call vote. And also, just as sort of a side note, we're working really hard to make sure that we're ADA compliant. And so that means transcripts available. And so we're going to have to probably be a little more formal in our discussion, meaning that we'll have to announce ourselves so that the transcript can capture it and create that transcript for those that might be participating that might be otherwise impaired. So we'll do roll call vote today, and then just we'll kind of get in the practice of doing that, and we'll get better at it as we go. But as we discuss, just your name would be fine, and then make your comments then. All right. Meeting notice of the February 19th, 2026 meeting of the Board of Examiners for Land Surveyors has been noticed on the website since September 26th, 2025. This month's agenda was posted on February 12th, 2026. Before we adopt the agenda, I'd like to just propose one amendment or edit. If we may add the legal report right behind professional society report, I'd appreciate that. Just want to move that up if possible. And then we'll entertain any other edits. And if not, then I guess a motion and likewise.
Okay, so do we have a motion to amend the agenda to do the legal report immediately after the professional society report?
Tommy Young, so moved.
Justin Rain, second.
As by, I guess, roll call vote. Kevin Martin,
Aye.
Justin Rains,
Aye.
Tommy Young,
Aye.
Gary Clark, aye as well.
All right, very good. Hey, you guys did great first time out. That was good. All right, thanks. Professional society report. Jay, are you on? If not, we'll come back and get him whenever he's able to join us.
Do we want to do the approval of the meeting minutes from last week first?
Thank you. I skipped right past it. Guess we weren't interested in posting that then, but we'll do that. Yeah. Thank you.
Very well. The meeting minutes were both posted online and in the materials passed out to the board members. Are there any edits or changes proposed? Hearing none, then I'll accept a motion to accept as submitted.
Justin Rain, so moved.
Tommy Young, second.
Roll call vote. Kevin, all in favor say aye. Kevin Martin,
Aye.
Justin Rains,
Aye.
Tommy Young,
Aye.
and Gary Clark, aye as well.
Good.
Very
All
well.
right. I guess the professional society report. Jay, are you online? Let me take a look. All right. We may have to troubleshoot with him. Let me just pause for just a second before we move on. Jay, are you with us? Can you speak into the mic and see if we can hear you?
Yes, sir. You hear me?
Oh, yes, sir. We can hear you.
There we are. There we
All
are.
right.
In
Thank
technology,
you.
great.
Yeah, thank you. All right, Jake, go fire
Well,
away.
thank you. Yep, thank you. Thank you. I did get a last minute call this morning from Jimmy Cleveland asking me to take his place this morning for the TAPS report. He's a little under the weather, so we certainly hope that he gets to feeling better. And gives me the opportunity to hear some familiar voices. So it's always good to hear everybody's voice there. Real quick for the TAPS review, of course, the biggest item on the agenda would be the upcoming TAPS conference scheduled for March 5th through 7th. And no doubt the highlight event of the conference this year will be the Board of Examiners seminar scheduled for Saturday at 9:50. Certainly looking forward to a riveting presentation from all members of the board there. Among other presentations that'll be there, and certainly, of course, the opportunity to gain plenty of PDHs there. So that certainly is number one on the agenda. A couple other items that we're following as the legislative chairman of TAPS. Of course, obviously the legislation is in, or the legislative body is in session. Two bills really that we're following, one of which I'm sure y'all may discuss later on today would be Senate Bill 2224, which is the combination of, or the combining or blending of the AE board with the Land Surveyors Board. It did go through a vote, committee vote yesterday with a 6-2 in favor, and seems to be sailing right through as best I can tell. The other Senate bill that we're watching is 1814, which would make it a Class A misdemeanor for the moving, altering, or destroying of a property corner. I think this is sponsored by a couple of TAPS members, a couple of guys that are certainly prominent in the profession. And it sailed through a Judiciary Committee vote yesterday in the House, 22-0. So it seems to be well on its way as well. Those are about the only two things really that we have our eyes on as far as legislation goes. A couple of other minor bills that aren't directly related to surveying that we're certainly watching. But short of that, unless there's any questions or comments from the board, I'll turn the microphone back over to you.
Any questions from the board members? Hearing none, I guess we move on from that. Thank you, Jay.
Thanks, Jay.
Very good. Thanks, Gary. All right.
Thanks,
go
Jay.
ahead.
All right, looks like we're at the legal report then.
Okay, thank you, Glenn. This one is kind of long, but none of the complaints are terribly long individually, so I'm just going to read it. And if you decide you want me to stop reading it verbatim, just let me know. Okay, number one is 2025056551. Complainant filed this complaint against respondent, a licensed land surveyor, regarding a survey respondent completed for complainant's neighbors. Complainant alleges that respondent's survey plat recorded on July 31st of 2025 for complainant's adjoining neighbor improperly shifted the neighbor's northwest corner from an established monument at the westerly terminus of a public road to an existing concrete marker at the easterly terminus. This change appears to be in conflict with prior deeds and surveys, converts a prior encroachment into the neighbor's platted boundary, eliminates the complainant's shared drive access, omits a documented 30-foot easement crossing the new tract, and contains record citation errors. Respondent states they were hired to survey a new 15-acre tract for their client's daughter and created a 25-foot egress easement through a parent tract to an existing gravel driveway that meets a public right-of-way. Respondent explains this was done as a result of a one-access policy. Respondent states the easement exposed a boundary conflict with the complainant and their neighbors. Specifically, respondent cites long-term possession of a driveway and fence and a buried non-standard concrete marker approximately 18.5 feet from a monument as justification for the northerly line. Respondent included the driveway area by strength of possession, acknowledging it could encroach on complainant's deed. Respondent admits to not verifying the complainant's frontage and believes that the driveway was not the primary access to the complainant's property. Respondent's survey created the 25-foot access easement, but omitted an existing and separate 30-foot easement at their client's request, believing it unused. Respondent admits a deed book typo and missing plat citation, which is referring to another surveyor's survey, and says they should have labeled the complainant's line as possession only in conflict. Respondent further admits that a revised plat may be needed. Respondent's opinion is that litigation may be required to settle the matter between landowners, and their survey has made the issues evident and available to the complainant and the public. So we had an expert review of this matter The expert first notes that the root cause of the complaint is a boundary dispute. The complainant believes they are being encroached upon by their southerly adjoiner, but does not have their own survey and has not brought any action against the adjoiner, like in court. While the expert believes this is a civil matter, there are several concerning items worth noting about the respondent's work and actions. The first one is a vicinity map and or a descriptive location of the property appear to be missing from both the drawing supplied by the respondent and the recorded document supplied by the complainant. The second one, the drawing provided by respondent in response to this complaint does not seem to bear their seal and does not appear to be marked preliminary. The third, respondent failed to show an easement that is apparent and obvious in the record, purportedly at the request of their client. The easement appears on the previous work of respondent. Number 4, the respondent notes the north and east boundaries are subject to verification by a current field survey and have been taken from an unadjusted 2008 survey by another licensed surveyor. The north and east lines generally seem to align with the other survey, except the final calls at the driveway access point where the boundary issue seems to be. If respondent is using the other licensed surveyor's survey for the north and east lines, then the line should hold a specified numbered concrete monument. Instead, they deviate, removing access from the complaint. The 5th issue, respondent admits to not verifying the complainant's frontage while adjusting the other survey's line to honor a different monument. The citation for complainant's deed is also incorrect on respondent's recorded plat. Number 6, the respondent failed to notify complainant of the discrepancy in the area of the driveway. Number 7, basically in summary, the expert reviewer believes that the information provided by the complainant and the respondent depicts a scenario where the respondent is operating below the normal standard of care that land surveyors are held to in the standards of practice. So I don't have any precedent for these specific technical violations. I definitely don't have any of them combined together. So I just recommend that you guys discuss if you think this is worthy of a letter of warning or a civil penalty or continuing education above and beyond what is required, or a combination of a fine and education, or a combination of a letter of warning and education, or any of those by themselves. So you are authorized in your rules, if you decide on a civil penalty, to issue a civil penalty of as low as $50 per violation up to $1,000 for each violation.
Thank you.
You're welcome.
Oh, this is, to me, we have a number of violations here that the bulk of them are violations of the minimum standards, which essentially is a checklist, but they're easy enough things and obvious to go with. The fact that there's so many of them concerns me. But there's also, there's 2 in here that really are, surveying, of just not quite doing your job correctly, in my opinion. And that's where I think that crosses over into an actual of justifying a civil penalty onto it, as opposed to a letter of instruction or a letter of warning. I'm not sure the additional education would be of any particular benefit, compared to, as I see, he's been licensed since '88, so he's been doing continuing education courses for a number of years anyway of that. But this does concern me, that this is not what we really want to be out there. Anyway, that's my initial thoughts. What, again, and this is Gary Clark speaking. Comments from?
Yeah, this is Kevin Martin. It seems like to me, being the non-surveyor member of the board, some pretty basic things were missed. The lack of stamp and the lack of preliminary, that seems like a pretty novice mistake, and it also seems it's analogous to my engineering career, where we made sure that prints that weren't official had any kind of preliminary, drawing, tooling prints and so forth. We made sure those were preliminary all over the print. So I feel like I'm with Gary that some pretty elementary mistakes here, it seems like to me.
Thank you.
That's Kevin Martin again, if I didn't mention that.
Thank you. What do you think, Justin?
I agree with this Justin Raines. I agree with both of you. Several of these rise beyond the letter of warning. For me, the ones that really concern me the most, not notifying the adjoining property owner when there was a discrepancy. That's cut and dry, clear. We have to do that. And that was also a lot of the nexus of the problem here. If that had happened, it would have solved a lot of this. And depicting another surveyor's work on your drawing without, notifying, noting it as done by others. And submitting a drawing to the board, right? That was the drawing that was sent to the reviewer.
Yes, yes. So, I don't know what was given to anybody else, like what was given to their client, or if they gave a copy to the complainant, but I just know what they gave to us with their response didn't say preliminary.
Yeah, I mean, I think several of these definitely rise to the level of a civil penalty.
Thank you. Tommy?
Tommy Young, I agree with all that. Numbers 1 and 2 are pretty minor. Not having a vicinity map or not putting preliminary on the drawing, but the others are more serious, like using another surveyor's work without actually holding the monuments they used, not notifying the adjoiner about an apparent major discrepancy. That's a problem. Not putting an easement on there because the client didn't want it on there, I think was one of them.
Yeah,
I think we got some problems with this work.
thank you. All right, then, Gary Clark again, I'm gonna say, I think we have 3 of these problems that rise to the level of a civil penalty. The others could be just a letter of instruction, but with that, I think I tend to recommend a $1,000 fine for each of those 3.
And would you say number 3, 4, and 6 are the violations that you feel are the most major and worthy of a fine?
Yes,
So that would be a $3,000 penalty total.
right. And I mean, there's one here that is kind of borderline. I would almost throw that in as well. But yes, those 3 I think are the major ones that really rise above just merely doing a sloppy map. This is going to actual survey work.
And just for the board's understanding, all of these violations will be included in a consent order. So none of them will be left out. It'll just amount to a $3,000 civil penalty.
Right. But yeah, that's my recommendation. So I'll entertain a discussion or a motion.
Go ahead, Tom.
I don't know where we'll go off. Tommy Young, do we want to penalize them $1,000 each for those 3 counts?
That's my recommendation. That is what I am recommending and proposing.
Okay, then.
Kevin Martin, I would agree with that.
Okay. Somebody making a motion.
I make a motion that we issue a penalty of $1,000 for each of those 3 counts, being
For a total of
for a
$3,000.
total of $3,000.
All right,
Justin Raines, second.
very well. So we have the motion to do a civil penalty of $3,000 All of them will be, as Eric has said, be mentioned in the consent order. And by roll call vote, Kevin Martin,
Aye.
Justin Raines,
All right,
Tommy Young,
Aye.
and Gary Clark, aye.
Okay, number 2025066651. I am going to summarize this one because I actually just spoke to the complainant 2 days ago over the phone. I think this is included in the summary as well, but they've made it clear they don't feel like respondents done anything wrong. They were just frustrated. They don't want to pursue this complaint. And basically they have a boundary dispute with their neighbors, and the respondent was hired to kind of assess the situation. There's a lawsuit going on. So my recommendation is dismissal.
Reading Gary Clark, reading through it myself, but particularly since the complaint is pulled out, I don't see any reason to pursue this one. So do we have a motion to dismiss or discussion?
Justin Raines, move to dismiss.
Tommy Young, second.
Any further questions? Then by roll call vote, Kevin Martin, how say you?
We didn't get you there, Kevin. I think you were muted.
Aye.
Justin Raines,
All right,
Yeah.
Tommy Young,
Aye.
and Gary Clark, aye.
Okay, number 32025065661, and I think I can summarize this one pretty well. The complainant filed a complaint with the Tennessee State Fire Marshal's office about a family dispute, child custody issue. Complainant filed this complaint about respondent filing a complaint with the State Fire Marshal's office. And the sole issue is that respondent calls themselves a land surveyor in the written complaint. So complainant feels that that's unlicensed activity. Respondent admits that they did that. They kind of argue that they didn't state they were a licensed land surveyor. And of course, we know the rules. That doesn't matter. Doesn't matter if you use an adjective or not. But I think maybe a letter of instruction would be appropriate here because it really has nothing to do with the respondent engaging in any kind of surveying or advertising themselves as a surveyor. I think they made a mistake. But I don't think it's harmful to the public in any way. And I think a letter of instruction would probably do the job. They would not do this again. So that's my recommendation.
This Gary Clark, I read through this. I couldn't really figure out why we were involved in it to begin with, other than that. I can't figure out what the surveyors got to do with the complaint that they were dealing with. But I have a little problem with penalizing him too much because yes, the specific law says you can't refer yourself as a land surveyor, but I think in context that is more about offering the product, the service of land surveying, or trying to get around the rules of it. Typically everybody in my staff, I refer to them all as surveyors or land surveyors. I'm just the one with the license, and they're part of the team. And I really prefer the folks who work for me and are in land surveying, to be able to say that they're a surveyor and say it with some pride and swagger. They're in the pipeline to become the license, and that counts. So I think it comes down to a matter of context right here. And the fact that he put it into a written document, he probably should have clarified that he works for a land surveyor instead of the land surveyor, because that does leave a little bit of wiggle room for somebody to misunderstand. I think a letter of instruction just kind of detailing that is where, you've got to be aware that you have to be careful when you're non-conversational and actually doing something that might be taken as an official, that yes, due to he has special knowledge, which justifies to me himself calling himself part of the land surveying community, but yet he does not have authority. So he's got to be careful he doesn't cross that line in any of his documentation or so. Comments, questions?
I agree with all that. Yeah, I know exactly what you're talking about. You know, in the years before I was licensed, I still considered myself a surveyor,
Mhm.
even if I wasn't a licensed land surveyor. So I understand how that becomes a slippery slope though,
Yeah.
when you start to put
Well,
it into things like that.
I think Gary, again, yeah, I think it's worth a letter of caution to say that, yeah, you got to be careful, be aware. And
Yep.
Tommy?
I agree with both of y'all.
Okay.
I mean,
Justin Raines, make a motion to accept legal's recommendation for a letter of instruction.
Kevin Martin, I second the motion.
Roll call vote. Kevin, how do you say?
Aye.
Justin?
All right.
Tommy?
aye.
And I for me as well.
Okay, number 4, 2025061701. Complainant hired a respondent, a licensed land surveyor, to survey a lot they just purchased. Respondent was selected through complainant's realtor. Respondent informed the realtor that the survey was completed, sent an invoice, and the complainant paid for it. Complainant alleges that respondent has not responded to their request to obtain the original survey, noting that they've never spoken with respondent. Respondent states that in August of 2025, the realtor asked them to survey a parcel of land. Respondent did the work, emailed the drawing and invoice to the realtor. Respondent confirms they received the check from payment from complainant, even though they were not hired by them, and also confirmed they'd never spoken with complainant. Respondent told the realtor that they could pick up the original copies whenever it was convenient. Later, respondent received a call from the county sheriff stating complainant was trying to contact them, but was having trouble doing so. Respondent told the sheriff that their office hours were in the morning before noon, and complainant could pick up the plats anytime before noon, Monday through Friday. Respondent states complainant sent a lady to their office to pick up the plats, and the sheriff's office called back to state the complainant had withdrawn their complaint with the sheriff's office. Complainant then continued to send correspondence to the board after the respondent, explained this and rebutted. They want respondent reprimanded for never corresponding with them as a client, causing them to have to involve the sheriff. Complainant claims it took 6 months, but that does not match the timeline that I see with based on what complainant's provided me and respondent has provided me. Complainant alleges respondent told them they would only provide an emailed version of the survey. This is an allegation, which also seems to be in conflict with the statements that they never spoke with respondent. Complainant confirms they received the original survey and plat. Complainant alleges respondent is lying. However, it appears respondent's statements are also confirmed by complainant. So it's really a he said, she said. The complainant has what they want. So my recommendation is dismissal.
So
Can I-
moved. Well, would it be possible to get this client's name so we know to stay away from this person?
Can I ask, what county did this occur in?
I
Say
can't
that.
say.
Okay, more as you can call the sheriff's department for failing to return a phone call.
It's probably not Davidson County.
Well,
Guarantee you that.
one of my comments here is, this is not an unusual situation where we're dealing through a realtor or a third party, and it's not the person that's actually paying the bill. And that is ripe for misunderstanding. And a simple 1 page, 1 paragraph, 1 sentence contract to the way that I get by it is I would just send the realtor, this short contract saying, sign this, that you're going to pay. That immediately they send it to the guy who's really going to pay, and then who is involved for real. I think that settles a lot of the miscommunication. I'm going to suggest that maybe a letter of instruction pointing out that this problem would not have happened if you had used the contract.
Is that within our purview?
I mean, as far as I know, there's no rules or statutes that require you to use a contract.
No, there isn't.
But a letter of instruction is not alleging you committed any violations either. Although, I would caution even instructing a surveyor to do something that's not required by law.
Well, again, that's scary speaking again. I mean, we're actually, as professionals, we're expected to operate a little higher than merely the law. You know, in this case, my feeling is that by not properly communicating with the parties involved, that they have caused, the professional has caused inconvenience and angst to the public that he should be protecting in the way he operates his business.
I also, I don't think we know that there wasn't a contract.
I thought it said in there that there was not a contract.
I know, I think that says that in a different summary,
Yeah.
but I'll look over it one more time.
Okay. But, in any case, that would be my suggestion, unless that's absolutely beyond what we're allowed to say. But my rationale with it, that there's obviously a bit of miscommunication here and that this could have been cleared up by the professional easier.
Yeah, number six is the one that says there's no contract. So I think there might be some misunderstanding. I don't have any proof on the one we're talking about that
Yeah,
there was no
I guess
contract.
on this one, I'm just operating by my experience of how those things usually go. It's
Okay.
small surveys, realtor calls, we give me a survey, we do it, somebody pays it. But
And Tommy Young, while I agree with what you said, Gary, there are some clients out there that are just absolute lunatics. And this may be one of them, for all we know. I mean, this surveyor man, done everything by the book, and this person is just wacko. So I don't know that we have enough information necessarily to tell them to do better.
Yeah, it's Justin Raines. Yeah, well, I'm really unclear. It seems strange to me that how did the expectations get set on when the things should be delivered and things like that? If there was never, how was there even an engagement to do the work if there's never been any contact? That doesn't.
Right. From
make any
what I
sense.
understand, the contact was with the realtor, and the realtor is not the one that filed this complaint or alleging there was any problems.
Well, Gary, again, it may be just the public record of this discussion is sufficient if the respondent that's listed again, that he could take some steps to make his life easier. What's the motion, fellas?
I move we dismiss.
Justin Raines, second.
Very well, roll call vote. Kevin, how say you?
Aye.
Justin?
Aye.
Tommy?
Aye.
Aye as well for me.
Okay, number 5, 2025069-361. Complainant hired respondent, a licensed land surveyor, to do an easement on their property. Complainant states that the road that was supposed to be surveyed received some of the pins and stakes, but they did not do the easement to show on both sides of the road in which it was not complete. Complainant had their plats with seal on all of them way before they came back to set their center pin in the road. Complainant's court date was over in October 2024, and they couldn't take pictures of it for court, end quote. The complaint does not make any further allegations or provide any other details or supplemental documentation. Respondent confirms that they were hired by complainant to locate and show the location of an existing gravel road as it sits today and the location of an agreed upon ingress-egress easement that was recorded in the Register of Deeds office. The purpose of this survey was to show complainant's attorney the location of the existing road location and the center of the recorded easement for a pending court case in which complainant is the defendant. Respondent had felt bad for complainant because another surveyor was supposed to complete this work but never showed up, and complainant was in a bind, so they wanted to help. Respondent completed the survey on October 30th, 2023 for the court date that was originally scheduled for November 1st, 2023, and then the court date was moved to October 23rd, 2024. Respondent had explained to complainant that they wanted to wait until after the judge made their decision and ruling to place the monuments in the center of the road. Respondent testified at the trial, and complainant told respondent that they were fine with waiting for the judge's ruling. Respondent later set the corners for complainant's property and clearly flagged them all, noting complainant was with them and their crew at every corner that was set and flagged. Respondent explained the rebar is in the corner of the property and the easement is 12 feet wide on each side of it, and for a total of 24 feet wide. They walked the entire exterior of the boundary of the property, and respondent made sure complainant understood everything. The neighbor came out and drove down the common boundary line without any objections to what was being done by respondent and their crew. However, this neighbor later filed a separate complaint with this board against respondent, and that was already presented to you and closed without action at a previous meeting. Respondent believes they are being dragged back into more boundary disputes between complainant and the neighbor, noting 2 separate lawsuits regarding the property that respondent is aware of. I didn't see any evidence of violation, so my recommendation is dismissal.
Gary Clark, I don't see any violations here. I would recommend us agree with the recommendation.
I agree and move to dismiss. Justin Raines.
Kevin
Second.
Martin, I second.
Okay. Roll call vote. Kevin, how say you?
Aye.
Justin?
Aye.
Tommy?
Aye.
And I for me as well.
Okay, number 6, 2025073241. Complainant hired respondent, a licensed land surveyor, to survey their property because they were concerned their neighbor may be encroaching onto their property as they were building a new home next door. Complainant alleges respondent did not offer or provide a contract. Complainant alleges respondent sent 2 unlicensed workers out to their property, and after they were done, complainant expressed concerns about their work and the fact that the above-ground utility boxes located on both properties were not shown on the survey provided by respondent. Complainant alleges the crew only used a small shovel, a metal detector, and a large measuring tape wheel. Complainant bases this allegation on what they saw on their home surveillance cameras. Complainant alleges that because respondent never came to their property to investigate their concerns about the property line at the utility boxes and allegedly failed to research them in advance of the survey, strongly suggests that respondent had no direct involvement or supervisory role in the surveying of the property. Complainant alleges respondent should not have sealed and certified the survey as being true and accurate. Respondent confirms they were hired to do a land survey for complainant and alleges complainant is upset the survey did not produce the results they were looking for. Respondent did not provide a contract because they had discussed at length what services would be provided, including an email in which respondent responded to 6 detailed questions from complainant about the job and what to expect. And I got a copy of that as well. Respondent doesn't typically use contracts unless they are involved in a major project. Respondent claims complainant is being untruthful about the equipment used at the site. So I asked them for a specific list of what was used in the field. And I listed them 1 through 5. Respondent did not show the transformer box on this survey because the box is located within the public utility easement, and complainant never mentioned the transformer box until they had possession of the survey. Respondent denies complainant's claim that utility boxes have any bearing to property lines. Respondent did include the public easement on the survey, and their standard operating procedure is that when there is an easement of record, they do not locate or show any infrastructure within that easement. Respondent argues that the transformer does not affect the property at issue and has no bearing on where the property line is. Had the transformer been located outside of the easement, they would have shown it because it would have an effect on the property. Respondent states that their crew was at the property on a Friday afternoon, and complainant called Monday morning after they viewed their security footage and listened to secretly recorded audio conversations between the crew members before they ever had a chance to look at the field work. Once respondent downloaded the points and did the line work, it was obvious that the crew had done the calculations correctly and there was no need to revisit the site. Respondent did not visit the property, stating it is standard practice in Tennessee and noting their field crew has about 80 years of combined experience at their company. In response to complainant's allegations that respondent failed to have a supervisory role or direct involvement in the surveying of the property and failed to conduct research, respondent explains that they researched documents with the registrar's office to find the recorded warranty deed, which is indicated on the survey and on which the survey is based. Respondent also researched various foundational tools housed at the registrar's office, including relevant pages of the plat book and instrument numbers. Respondent inspected the field notes and the electronically collected data and made the geometry calculations to come up with the final survey. Respondent states the survey is correct to the best of their knowledge and belief, confirming they did everything the complainant asked for. I did not see any evidence of violations, and my recommendation is dismissal.
Excuse me, Gary Clark. Well, I take a little issue of a couple things that he has in here. I don't believe it's actionable, but stating that it's standard practice in Tennessee of not visiting the property, I think is a reach. But most of the complaint that I see from the complaint here is just not understanding how a surveyor goes about doing the job. And I see no real problem in that. But I do take issue with him talking about that there's no need to locate any infrastructure that's within the easement, even if it's on the property, because it's in the easement and it doesn't affect the property. I think he's incorrect there. If it's on the property, it's on the property and it affects it. The easement merely defines the legal right to use it for that. And both should be shown on it, in my opinion. I feel like he's actually in violation of section 0820-03-06, section 7 and 8 regarding easements. And, I suggest a letter of instruction to that effect. But the discussion from my fellow members.
Yeah, I would agree. Tommy Young, I would agree. I guess clause 7 says visible and apparent rights of ways, utilities, and roadways will be accurately located when crossing or forming any boundary of the property shown. That pretty well spells out if utilities are on the property, you need to locate them.
Yeah, Justin Raines, I think his argument was they were in the right of way and not in an he said if it had been, we wouldn't locate it, which you're right. A letter of instruction might make sense there to tell him, no, you're wrong about that. But I think he was saying that in this particular case, the transformers were in the right of way, though you could get into a whole thing about, well, was it fee simple right of way? Is it implied dedication right of way? It may actually be on the property.
Yeah, I don't think he actually says the word right of way. He uses the word easement.
Okay, maybe I misread that.
Yeah, it's kind of the way I read it, it was definitely on the inside of an easement across the property.
Okay.
But again, his statement that he never does it, I think he's misinterpreting those rules and it's worth a letter of instruction.
I would agree with that. And I also agree with your statement on standard practice in Tennessee not to visit the site. That is a far stretch. Wouldn't call it a standard in any way.
All right, do we have a motion? Or Kevin, you got anything to add to that?
Just my thought was if I were receiving the survey, I would want those boxes marked. Those transformer boxes, I don't know.
Helps somebody, a layman, understand where everything is, and you can see something visible.
Exactly. Maybe I might not know those were there. I mean, maybe they're obvious. I don't know if there's giant boxes above the ground, but it would be nice if you did know that now you've got that, marked on the print. So
Yep.
I would agree with what you guys are saying though. In general,
Okay, do we have a motion?
So moved.
Justin Raines, second.
Any thoughts, Erica, before we go further on that?
No, if it makes, I guess I would like to note that exactly what y'all are talking about, the transformers not being marked, that was really the biggest problem for the complainant. And so the respondent didn't address that in his response. So I specifically asked those questions, and that's where I got this information. So I just want to emphasize that he emphasized that he believed that was not required. So
Yeah.
I think a letter of instruction will be really helpful in this.
Okay, very well. Then we have the motion. No further comments. So we'll have a vote. Kevin, how say you?
Aye.
Justin?
Aye.
Tommy?
Aye.
And Gary, aye as well.
Okay, that takes us to number 7, 2025-076-731. Complainant states that they have had multiple surveys done by different land surveyors. Complainant alleges the surveyors continue to say their boundary lines are wrong between complainant and their neighbor. Complainant claims their map and parcel say one thing, but the surveyors state they are wrong. Complainant has lived at their residence for 25 years and nothing has been mentioned about the boundary until a new neighbor moved in. Complainant has had 3 title searches on their property. Complainant just wants someone to look at the information they have. Complainant does not make any allegations against respondent, but filed this complaint against respondent. That's the only place is the name of the person the complaint is filed against. Otherwise, they don't mention any allegations against that respondent. So the respondent states complainant's been looking for a land surveyor to survey their property for a while. Respondent met with complainant several times to go over their deed and has really tried to do their best to explain to them, like, respectfully, that respondent surveyed the adjoining property to complainant's west and that complainant needed to hire another surveyor to survey their property in order to obtain another surveyor's opinion. Respondent also told complainant during one of the meetings that if complainant and the adjoining neighbor could meet and discuss the shared boundary, then a boundary line agreement could be formed to eliminate any boundary issues if both parties agreed to do so. Respondent feels they've conducted themselves professionally and ethically to give complainant the correct guidance to obtain another survey from a different land surveyor so they could receive a fair and professional opinion regarding the shared boundary at issue. Respondent had surveyed the adjoining property in December of 2012, over 13 years ago. And just to be clear, they've never performed any services for the complainant. So I didn't see any evidence of violations and I recommend dismissal.
Gary Clark, yes, I wish we could send this guy a letter of commendation for doing so much without compensation or appreciation. He really, illustrated himself as a professional, but lacking our ability to do that, I agree with the dismissal.
Tommy Young, it almost looks like this complainant is mad that the respondent won't work for them. This is what it seems like.
It just seems like the complainant is mad about, everything having to do with this issue. So, and it's unfortunate that, we can't help him in that regard.
Have a motion?
Move to dismiss. Justin Raines.
Tommy Young, second.
Any further discussion? Then roll call vote. Kevin Martin, how say you?
Aye.
Justin?
Aye.
Tommy?
Aye.
And aye for me as well.
Okay, number 8, 2025-071-891. Respondent is a licensed land surveyor in Tennessee and has been licensed here since January 11th, 2019. Respondent resides in Alabama and is also licensed there as a land surveyor. So we opened this complaint because respondent self-reported discipline out of Alabama when they submitted their most recent license renewal application. They provided a copy of a consent order that related to 2 complaints filed against their land surveying license in Alabama. It outlines the facts and it led to a $1,500 fine, and respondent is required to submit a quarterly list of all land surveying projects that they perform beginning on July 15th, 2025 through April 15th, 2026. So they submit that to the board in Alabama. Respondent stipulated that they accepted payments for surveying services they failed to complete for 2 separate projects in Alabama. The first one, they received $1,750 to complete a survey, which they failed to complete in a timely manner. And then the second one, they received an initial payment of $1,000 to begin surveying work for a project in Alabama and later requested the final payment of $1,000 for the services, but failed to complete the survey. So the consent order, the respondent admitted to all that, took that settlement offer in the form of a consent order and signed it on April 18th, 2025. So the board here is authorized to take disciplinary action if you feel that that is appropriate. However, I would recommend a letter of warning to the respondent based on their violations committed in Alabama.
Gary Clark, I agree. A letter of warning is warranted, and I think that's sufficient. Discussion, Tommy?
So, what will be warning him about? Don't take money and not do the work?
It's just basically warning him that the board can take discipline if they continue to commit violations in other states, and just putting it on the record really for his license
Yeah.
here.
Okay.
We're just saying we recognize what you did and that you were fined for it. Don't come here and do it
Okay.
again.
Real quick, this is really dovetails into our discussion about letter of caution for discipline in another state. We're gonna have that discussion later on in the flow. And then document number 6 lets you see what that letter would look like. And so it's just basically to what she was saying, that we're aware, but and it's gonna be less of that action. So maybe just for this case, I would suggest just using the same language as we would use for a letter of caution instead of a letter of warning, just to be consistent, since we're gonna be doing that. They're gonna have that discussion later on. But the criteria is any action less than a revocation, suspension, or voluntary surrender, is really the criteria. And this would kind of fall into that basket.
Okay. Further discussion or a motion?
I just had a question. Maybe we don't know what we don't know, but what percentage of licensed surveyors would self-report? Or would the state notify our state regardless of whether he self-reported that?
I didn't know if anyone wanted to jump in there. This is Glenn. They will typically, in many jurisdictions, they're required to report that, and I believe to include ours as well. But sometimes they'll do that in the renewal. But like, for example, in A&E, they're required not to even wait to the renewal. It's like 60 days of the infraction there to notify you. And that can also, just from a practical standpoint, that can happen at NCEES as well. Other jurisdictions post enforcement there. We do as well. And so, we're going to see that when it's time for renewal. But yeah, it's, we don't get a lot of it, thank goodness, but yeah.
Isn't there a box to check about
Yes, sir.
being
Mhm.
sanctioned in other jurisdictions?
Yes, sir. Mhm.
Okay, so that's where we got him
Right.
on this one, I guess. Okay.
Okay.
All right, is there a motion?
I moved to dismiss.
Not the
Or-
letter of
I'm
warning.
sorry, letter of warning.
Okay.
Or
I'm
can we
sorry.
just can we
Let
just use
me,
language?
let
letter
me
of
start
caution?
over again. I move we issue a letter of warning.
Can we just use that language, letter of caution, just to keep consistent in case there's some, yeah, so I don't want to confuse folks later since we're talking about it.
I move we issue a letter of caution.
Thank you, appreciate it.
Justin Raines, second.
Off question, hearing none, we'll do the vote. Kevin, how say you?
Aye.
Justin?
Aye.
Tommy?
Aye.
And aye for me as well.
Okay, that takes us to number 9, 2026002981. Complainant alleges respondent, a licensed land surveyor, came out to their property on December 10th, 2025, and moved a property pin 100 feet from its original location and claimed there was an offset. Complainant told respondent they did not have an offset and brought out their deed to confirm there was no offset. Complainant states they contacted their town records about this and were allegedly informed they don't have an offset and their property is a straight line. Complainant did not hire respondent, but states they originally set the pin 8 years ago. Respondent states the complainant statements in the complaint do not accurately represent their conduct or the facts of the survey. Respondent originally surveyed and subdivided a 250-acre tract into 35 lots in 2017. Respondent's client recently asked them to remark the unsold lots because many of the original markings were no longer visible. During this work, respondent's crew encountered complainant who identified themselves as the owner of a lot and accompanied the crew while they marked the adjoining lots. Along complainant's east boundary, there are 4 iron pins marking the back corners of 3 other lots. All 4 original pins were located with respondent's caps intact, but one pin was found approximately 60 feet from the corner location as shown on the recorded plat. After the crew reported their findings, respondent received the information and directed the crew to set a pin at the correct corner as shown on the plat of record. Complainant expressed dissatisfaction to the crew and later emailed respondent's client about their concerns. Respondent's client forwarded the email to them and respondent responded to the complaint the same day to explain the findings and the reason for setting a new pin. Respondent provides copy of this correspondence, the recorded plat, and a clipping highlighting the pin in question. Complainant asserts that their boundary line should be straight and that respondent moved their corner due to an offset and that this was done without complainant's knowledge and that complainant contacted respondent without receiving a response. Regarding the offset, it appears complainant misunderstood the crew's explanation. The crew informed complainant that the pin, as found, created an offset in what should be a straight line. This discussion occurred while they were marking the corner in complainant's presence, which contradicts the claim that the work was performed without their knowledge. The correspondence provided contradicts the allegation respondent ignored complainant. Respondent cannot determine what occurred between the original survey and the present, but the evidence suggests the pin was moved. The corner pin was reset in accordance with the recorded plat and in full compliance with the current Tennessee minimum standards of practice. Complainant then filed a rebuttal and denied walking around with the respondent's crew and states they told them not to trespass and leave the pins where they were. Complainant claims the crew told them the pins would not be touched and then later moved the pin. Complainant claims the crew ripped their trespassing signs down and cut their electrical fence. So there was a lot of he said, she said in this. I couldn't find any proof of any violations, so my recommendation is dismissal.
Gary Clark. Basically, yes, I agree with what you said there, that there's a lot of misunderstanding probably between what the surveyor was doing and what the complainant saw. As far as a pin being set that far off, it seems like they think they found enough evidence that it was, and probably this would have been going back to their notes to verify that they had set it correctly the first time and somebody had moved it. Even if they had said incorrectly, whereas it does cause a little bit of a legal problem, if it was that far off by an obvious blunder, I think the legal and correct thing to do would be to reset it where it should have been. In my experience, I have actually seen both of those things happen, including someone it was absolutely verifiable that someone had taken the surveyor's pin with the cap intact, and I don't know how they got it out of the ground with it intact, and moved it over into another location. So it does happen. And in this case, I've got firsthand experience of seeing that happen. So just to say that for record, I would agree with dismiss. Discussion?
Yep, I agree with all that. Move to dismiss.
I second
I
it.
also agree with. Sorry.
Okay. Kevin, you got any?
No, I agree with you guys.
Very well. We'll move to the roll call vote. How say you, Kevin?
Aye.
Justin?
All right.
Tommy?
Aye.
And I for me as well.
Okay, number 10, 2026-003-271. Complainant alleges they have attempted to call and text respondent, a licensed land surveyor, and have not received a response. Respondent completed surveys on 2 of complainant's properties. Complainant wants respondent to provide them with a letter verifying that existing fences on both properties are located within complainant's property boundaries and the neighboring fences are encroaching onto complainant's lots. Respondent states that complainant is arguing with their neighbor over a fence that ties into their fence. Respondent has surveyed both of complainant's properties and the fences were not built by the owner of either property. Complainant is complaining that their neighbor's fence crosses their property by 1 foot and wants the neighbor to remove the fence to leave a gap between the two, leaving a small portion of property that no one will be able to cut or mow. Respondent labeled this on the survey provided to complainant. Respondent does not want anything more to do with complainant because they believe they are trying to cause problems and be an annoying neighbor. Respondent does not feel obligated to do any more work for complainant because they have fulfilled their contractual obligations. The encroachment is labeled on the survey at 1.11 feet. Respondent does not want to be further involved in a dispute between neighbors over fences that neither person built, but will defend the surveys if they are subpoenaed to court. So I don't see any evidence of any violations, and I recommend dismissal.
Gary Clark again. As a surveyor, just as an editorial, so often we want to talk to everyone and say, y'all realize that you're still going to live next door to each other after all this is over. There's no violation here. I agree with dismiss. Discussion.
Tommy Young, there's no violation. We, as surveyors, have to be careful about ownership of things along the property line. So we don't know who owns those fences. We just know where they are, and that was shown on the survey. So I agreed with dismissal.
We have a motion.
I
Kevin?
make a motion to dismiss. No, I would agree.
Okay, so we have a motion. We have a second.
Justin Rain, second.
Very well. By hearing no further discussion, Kevin, how say you?
Aye.
Justin?
Aye.
Tommy?
Aye.
Gary is aye as well.
Okay, the last complaint is 2026-006-771. Complainant made an allegation that they paid respondent to complete a survey. When they filed the complaint, they alleged respondent had not finished the job and they wanted a refund. Since then, complainant almost immediately followed up and said that this issue was taken care of. So, and they're very satisfied. So my recommendation is dismissal.
Gary, again, I almost get a sense here that it was the fact that a complaint was filed motivated the surveyor to complete the survey. Did you have any sense of that?
I didn't.
Or was it just happenstance, just coincidental that?
I mean, it seems that would make sense logically, but I also rarely see a complainant specifically say that they're very satisfied. If they have if they're upset at all with what the respondent did, or, if this really.
I'm just a little concerned that would, if the surveyor was motivated purely by the fact that he got the complaint, but if it.
That could be the truth.
Yeah.
Tommy Young here. We are a powerful motivating force.
But I don't know, right now, I guess dismissal is probably the prudent thing.
Agreed.
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 I move to dismiss.
Justin Rain, second.
Any comment, Kevin?
No
Any
comment.
comment?
I agree.
Okay, then we'll have the vote. How say you?
Aye.
Justin?
Aye.
Tommy?
Aye.
And aye for me as well.
Okay, thank you. That concludes the legal report. I appreciate you letting me move it up.
No problem. And I do enjoy you reading them to us. That actually does help, but I'm understanding some of these, you're right. A quicker summary would have probably done it. We studied through it, but there's very interesting ones in this one.
Well, I do my best. Sometimes I do struggle with summarizing it. If you saw how much I had, you would realize how short of a summary it really is.
Thank you for your service.
All right, looks like we're ready for election of officers. Just let me tee it up for us if that's okay. DCA 62-18-106A4 states the board shall elect annually from its members a chair and a vice chair. Right now, our current chair, as you know, is Gary Clark, and our vice chair is Justin Rains. And so in keeping with the TCA and an annual requirement, we're going to go ahead and do that. And I just want to commend you on a formidable campaign. Everyone was, I was very impressed. We won't need a debate, I don't think. So I think a sufficient vote would suffice. So if there's a slate that someone would like to bring forward, and there's nothing that keeps anyone from serving consecutively either that I could see. I looked in the statute and didn't see anything there, unlike some of the other boards. Any discussion?
So what are we saying? That I'm the only nominee.
Do you want to do it again?
I saw
I'll
everyone
say
back away from him.
I am fine doing it again. I will point out that probably next time, which I would be in my last year by my current appointment, that someone probably needs to take the chairmanship at that time for sure, where I can be off to the side advising you where you're fouling up.
In consultation. Well, SB 2224 is if it goes through and consolidates the board, that would put our first meeting as a consolidate board with A&E in August. And so it wouldn't last probably. It'd be a short tenure probably if that one continues to go through.
Possibly, and I mean, I relied heavily upon Jay when I took chairmanship, and of course, I have one serious reprimand due to his counsel.
So yeah, if anyone wants to offer us a slate, then we can go from there and then discuss and then vote afterwards.
Hear no discussion other than.
All right.
Same officers.
All right. If you want to put that in a motion then, Tommy, Young is speaking. If you want us to give us is your motion to put forth Gary Clark as chairman and Justin Raines as vice chair?
Yes, it is.
Thank you, Tommy. Do we have a second?
Second.
I
We got a second from Justin Raines for a roll call vote. Kevin Martin,
Aye.
Justin Raines,
Aye.
Tommy Young,
Aye.
Gary Clark.
All right.
All right, that's passed. Then we'll put that forward. Thank you for helping us meet that requirement each year. And so we'll put that in the books and going forward. All right, education report.
I'm gonna go sit in the car and you holler at me.
Okay. What we're gonna do is Gary Clark does have a course at the very end, so we're just gonna separate his out. So the entire slate minus his. And then we did have some approvals come in for the rest. We had some pending, but those came in. So we're gonna vote on this slate separate his course, and we'll vote on his separate. Okay. So we just need a motion to accept the recommendations for approval for this slate. Of course, is minus Mr. Clark's course.
I have a question. What is on the status of pending?
Oh, that was just we didn't have our two sign offs for the transmittals
Okay.
yet, so that's what
Okay.
we're waiting on. But we've gotten those, so it's
Oh.
everything is approved. Is
Okay.
approved now, minus his course separately. So if
So I move we approve the courses.
all right, we've got a motion from Tommy Young to approve the courses minus Mr. Clark's course. Do we have a second?
Justin
Martin.
Raines, second.
All right, we got a second from Justin Raines for roll call vote. We've got Kevin Martin,
Aye.
Justin Raines,
Aye.
Tommy Young.
Aye.
All right, thank you very much. And then we'll go ahead and take the last course then, Mr. Clark. And he'll, of course, he already stated he'll recuse himself from that one. So do we have a motion to approve his course? Okay, yeah, if you could announce for the record then, Mr. Clark, that you're recusing yourself. I think you did so much in
Oh,
your.
sure, yes.
But yeah, just make it official.
Yes, I'm reclusing myself for this on that, and also not to make light of the unintentional violation last time. We do take this seriously, and what's just pointed out, yes,
All right.
we surely recluse ourselves in this situation.
All right, thank you, Mr. Clark. All right, then, so do we have a motion in that regard then?
Justin Raines, motion to approve.
All right, we got a motion from Mr. Raines. Do we have a second?
Tommy Young, second.
We got a second from Mr. Young for roll call vote. We've got Kevin Martin,
Aye.
Justin Raines,
Aye.
Tommy Young.
Aye.
All right, thank you, gentlemen. Appreciate your help. All right, looks like then we're ready for the director's report. We've got, let me see. I've only got one item, so I don't have any heavy lifting today. Looks like you and Erica were doing most of that. So let me get in there. All right. All I've got is for informational purposes only. It's the budget. At our last meeting, we covered the months through September. As a result, we'll be focused primarily on the last 3 months of record, October through December. The reallocation under other in November. If you look under November, I saw a reallocation there under other. It's like $317, but nonetheless, it's not a big amount, but I like to point them out when it's just something that's an irregularity or appears to be something different than the norm. That was an October credit adjustment coming from division legal and itemized there. Sometimes that we have division expenses that go across all the boards, and then when they when it's sort of, when they have to get the invoice and they realize maybe one board disproportionately used than other, then they'll credit back to different boards based on their use or lack of the use. So anyway, you got a credit for that. Then you got a reallocation under technology in December, the next month, you'll see there. There's a reallocation of 484. That appears to be an STS credit adjustment coming from Division IT and itemized there. So legal giving us a boost, and then IT's giving us a boost the following month. Then you'll see the only thing that I could see that sort of jumped out at me was that $3,870 in December under other expenses. And that was due to credit card receipts from all the renewals. Obviously, we're in a renewal cycle right now. And so, those credit card receipts coming in from that. Court reporter services from the November rulemaking hearing. You'll remember that one. We had a court reporter for that. Revenue processing fees and telephone, postal, and printing charges. So that was sort of a busy period for a lot going on. And then that was the granular sort of drill down. But just for the big picture, you'll see that we're back in surplus for November and December. And of course, that makes sense because renewals were opening November 1. And so, that's right on par for what we would be expecting. And we'll probably be in surplus through, I'd say, January, because we have some folks kind of late trickling in, but then they'll fall off. We'll be back in deficit for a while. But so far the ship is still right and everything's going where it's supposed to go. I didn't see anything else that jumped out at me. If you did, then happy to discuss that and follow up. But that was just informational purpose. I'll pause for a second if there's any questions, and if not, we'll move on to the next item.
And this is Gary. The items you point out were the only things that I saw jump up as well.
All right. Thank you very much. All right. Thank you. All right. We'll move. I think we're ready then for the next item, which is under legal, legislative update and display history. So Kyle, please, if you would.
Sure. So our TAPS representative pretty much stole my thunder on this item. The two bills that he mentioned were the ones that I was going to bring up to you all, but I think you all are already aware SB 2224. Still pending, but it would combine this board with the Architects and Engineers Board. Also combine the funds, and it looks like there would be a total of 15 members on that board with the 3 associate members. So if you have any questions over that, I'm happy to answer any of them.
I thought I'd read there would be 11.
So that's minus in total with the associate members, there would be.
Yeah.
Oh,
Yeah, the public members, the 11th.
Mm-hmm.
right. So who are the associate members?
That is the public member.
Well, you've got
But that's 11.
3. Yeah, there's 3 associate engineers that are sort of like an advisory council, for lack of a better term.
Oh, okay.
They're not voting members, so they're
Right.
not included, but
Okay. I
but
understand.
yeah, they do assist. So it'll be a big room, when you put that many people in. You're looking at 11 plus 3, so 14 people, but 11 voting members is
Okay.
Sorry, I misunderstood the question on that.
Yeah.
That was my understanding that
Yeah.
apparently they each get an assistant to help them do all the applicants.
Yeah, you guys need that, don't you?
Yes, we do.
Okay, well, if no more questions on that one, the other one that our TAPS representative mentioned as well, I was watching SB 1814. It does make it a misdemeanor to intentionally remove, alter, destroy, without replacing a property corner monument, historic land surveying monument, or geodetic control monument. And that looks like that one probably is going to pass, but it's still pending currently. That bill did open up Title 62, Chapter 18. So I was watching it for amendments, but there's been no amendments to your chapter currently on there.
All right.
Hey, Kyle, I had a question about that. Is it common in other states for this to be a misdemeanor? I mean, I'm just curious.
I'm actually not sure. I did not do that. I can definitely report back on that.
My understanding is that it's not an unusual law. In fact, I thought we had something similar to that already on the books in Tennessee, except it didn't define the monuments in the corner as well as this one did. It was more about, but there was a thing about it being I forget what level of misdemeanor for purposely destroying a property marker.
Class
Here's a
A.
question.
And then,
The previous on the legal report where the surveyor pulled the pen up. Could it be possible that he gets punished under this
It would,
statute? Because, you know, without getting too deep in the woods, once pens have been in the ground for a while, they sort of ripen into legal title, even if they were set wrongly.
I don't see anything that it applies retroactively, so he would not get.
Well, not,
punished at
well,
this
I
time.
know,
Yeah,
but going forward,
yeah,
obviously.
yeah.
No, well, I mean, that's kind of what I mentioned in the discussion on it, is that there is some concern about it
Right.
having been there for 8 years, but the fact that it was, in his mind, provable that it was not even a blunder, but was actually, he was positive it had been moved
Okay.
by somebody.
Okay.
So the penalty then, in my mind, would have gone to whoever you found moved the thing.
Right.
And that's, but
And then, like you mentioned, it does define those, what a geodetic control monument is, that kind of stuff. So that's probably the difference on what maybe would have already been on the books.
yeah, that was my take on it. It was just a much clearer definition of what constituted that.
And then lastly, just regarding the rules from November, we're still pushing those through, finalize some stuff. There's a few more layers of review it has to go through. And then hopefully we'll get that filed and have an effective date for you sometime soon.
Okay, any other questions or comments? If not, then I think we're ready to discuss disciplinary history. Let me just tee that one up. Last year, the board approved use of the letter of caution letter for those renewal applicants who self-reported discipline due to working on an expired license in other jurisdictions. So that was the only thing. It was just if you worked on an expired license. We've since expanded that to sync up with, to include anything less than revocation, suspension, or voluntary surrender. Of course, so if it's less than those 3 items, then it would just fall under a letter of caution. Basically, you can read that letter and it's, we're just putting them on notice that, hey, don't do that here. We're aware, thank you for reporting, don't do that here, and really it's really good timing because if we're going to be going over to A&E board, they're already doing that. So we're using basically the similar language and just, syncing up with them. And we've already done that basically on this last case we had. So, we've
Okay,
got
so
precedent as well.
So my understanding in that this one is specific for folks who had violated another state
Another state, not here.
and not here.
They've already been disciplined somewhere else and they've been, whatever disciplinary action they received, that was in another jurisdiction, but did not happen on our soil.
And I always have trouble with this where I keep hearing the letter of instruction and letter of warning. Are those actually one and the same or?
No, not necessarily. A letter of instruction is less harsh. They both do not, want to make clear, they both do not constitute disciplinary
Action, yeah.
A letter of instruction is more instructing, maybe you should have done this. A warning is more, in my opinion, where we're saying we pretty much did have grounds to issue a civil penalty, but we're
Okay.
not going to.
So
But we're warning you.
instruction is
Caution.
more of a friendly advice, like my instruction that if you'd used a contract, you wouldn't have this problem. Whereas the warning is we think you may have violated. This is just notification that if you do it next time, we're going to, and
That's a good way to.
that
put
we're
it.
going to have.
Yes.
So it being,
Letter of caution, more harsh than a letter of
Yeah.
instruction.
okay,
Yeah.
but all 3 of these, none of them actually constitute a discipline or something that's going to dog them on their record.
No, they do not constitute discipline, but it is maintained in the file. So if there's something happens in the future, you guys can be aware of that and you may
Okay.
want to issue a civil penalty.
So
at
it's
that
in the
point.
file, but it's not disciplinary. Okay, all right. Thank you.
All right. So, well, we've got some edits to that letter that include that language. If you look at that document number 6, the language there is review of the disclosed discipline in case the action taken was less than revocation, suspension, or voluntary surrender of your out-of-state license. As a result of this disciplinary action, the Tennessee Board of Land Surveyors initiated the above reference complaint against your Tennessee license, resulting in the issue of a letter of caution, which does not constitute formal disciplinary action. And then it gives authority for that down below and further expounds. But that was the language that we changed, is it's expanding it beyond just working on an expired license to anything less than those 3. And if it rises to obviously those 3, then that's a different story. You'll hear from that. You'll hear from us, and that'll be on the report, and you'll deal with that accordingly. And so then we'll just need, if that comports with the will of the board, we'll just need a motion to accept those amendments.
All right, I'll entertain a motion.
Tommy Young, I move we accept it.
And Justin Raines, second.
Any further discussion? Hearing none, we'll take the vote. Kevin Martin, how say you?
Aye.
Justin?
Aye.
Tommy?
Aye.
And I for me as well.
All right, very well. Do we have any new business? I guess we do need to do the PDHs.
We have no one on the list for any public comment this time?
We'll do that afterwards.
Oh, we
but
do this
yeah,
after?
Yes, sir.
Okay.
Yeah.
So I see we're probably gonna, by the time we do that, we'll be flirting with 2 hours. Is that right?
Move, we award 2 hours of PDH for this meeting.
Second.
Roll call vote. Kevin, how say you?
Aye.
Justin?
Aye.
Tommy?
Aye.
And I for me as well.
Okay, very well. All right, I think we're ready now for public comments. So we'll start with those that might be present, and then we'll work our way to the chat box to see if anyone signed in there and wants to speak. As by way of reminder, we want to limit comments to 2 or 3 minutes. We also wanted to limit to items on the agenda. And if there's any repetitiveness, please refrain if possible. So let me check to see if there's anyone present first. All right. There's no one present. There's no one signed in. Do we have anyone in the chat? Okay, no one in the chat. That concludes public comment portion. It is your pleasure to adjourn if you'd like to, Chair.
Any other discussion from the board? Hearing none, I declare us adjourned.
All
Thank
right,
you very
sir.
much.
Appreciate it.
Congratulations.